So welcome to the introduction to our disclosure workshop, California Real Estate Disclosures. Sellers, this is particularly for you, but buyers, these are the things you're going to be learning. You're going to be getting the disclosure, so you might as well understand what's happening. So let me just begin. I've got a bunch of, someone already joined the course from one video, from one live. I did a Facebook and YouTube live. Someone already joined, actually 2 people already joined. And let me just give a background. I got a few questions. And here's the point. Yes, in California, not everyone understands, but sellers are selling the property as is. Other than some federally mandated things like bracing your water heaters, the property is being sold as is. So let me pull that up right now. Is this? Oh, I might have. Why is this not? You are seeing that. Yeah. Okay. So, paragraph 11, condition of the property. Unless otherwise agreed in writing, the property is being sold as is in its present physical condition as of date of acceptance, and B, subject to buyer's investigation rights. The property, including pool spa landscaping, is to be maintained substantially in the same conditions at date of acceptance, and all debris and personal property and personal property not included in sale shall be removed by close of escrow. Now, seller shall, within the time specified in paragraph 14A, disclose known material facts and defects affecting the property, including known insurance claims in the past 5 years, and make any and all other disclosures required by law. Now, in paragraph 14, it's the timing of these disclosures, and we can get more into detail, but that's not what we're worried about right now. We'll discuss that in future videos. And right above this, these are some of the disclosures that are to be included as part of the deal. And we're going to go to these forms, the important ones right now, that most questions are, as a lawyer, I'm a lawyer and a real estate broker. My name is John McConnin, in case you're seeing this on YouTube. I'm a California licensed attorney and broker. I get called, and you'll see in these forms, realtors, it says something like realtors can advise about real estate. If you have questions about disclosures and the law, talk to a lawyer. So that's what we're doing now. I'm an attorney, and I've advised many sellers over the years who call me up. I've had relatively famous, you follow major rock and roll bands. I've had people call me up about disclosures on their properties. Famous people, everyday normal people in $300,000 houses, people in multi-million-dollar houses. They call up and say, I've got issues with my property. The garage isn't permitted. My property's over the line. I've got these cracks. Am I supposed to disclose? It's common. And oddly, this is the good thing about people. Many times people call me, and sometimes their realtors recommend they call me because they're over disclosing and getting it too complicated. So in our course, we're going to be talking about answering the call to question, just like it's a deposition. You may have heard that if you've ever been deposed and you've had a lawyer advising you. You answer the call to question truthfully, and you don't answer more or less. You don't necessarily have to explain it unless you can explain it in a way that's likely to bring more value to you. But you don't want to just ramble. So, that would be my caveat. Answer the call to question. You don't have to answer more than that. You don't have to answer general things. But let's say there was a crack in the foundation and you're disclosing that. You can say, we had a flooring expert come out and I can give you the report of the flooring expert. When you're preparing your disclosures, you might not say, we had the property repaired. You could say, an expert came out, they worked on the property, and we haven't had any leaks since, or we no longer detect the floor being warped, or whatever it is. You might want to stay away from the word it's fixed or repaired. You might want to refer them to the expert reports, or just say, ever since the people came out and worked on the roof, we haven't had any more leaks. That's what I would do. I've had a leak in my roof, and I actually, after we bought the house, I had insurance, but we had a leak on the pipes, and I would say that, and I'm not entirely sure every pipe in the house it's a pretty old house, has been repaired and the leaks are fine. So I'd say, the leaks we're aware of no longer leak. And so that's answering the questions. And now let's get into the major ones. I'd say the ones we're gonna talk about today in the introduction are the residential. It's called the TDS, the Transfer Disclosure Statement. And if you're using California real estate forms, the California Association of Realtor forms, this contract particularly, it says you should have answer the SPQ, which is the Seller Property Questionnaire. So we'll be discussing that. And in another video, I've already actually put out videos about this on the internet. If you're a trustee or someone who's exempt from doing a TDS, you'd also want to do the ESD. But we're going to cover that right here in the language, and we'll have videos on that in our course, our free course, at winnerscheck.org. On the front page right now, it just says, oh, let me pull it up. I don't know exactly. I wrote it last week. I'm going to pull it up. winnerscheck.org. I'll pull it right over. So here, Free Home Sellers Disclosure Workshop on the front of winnerscheck.org. That's my website. And so now, let's go into the disclosure situation. And then that'll do it for this video, and then we'll actually go to each one of the forms that we're going to be discussing. Seller shall, within the time period in paragraph 14A, and you can read 14A, but we're not going to worry about that right now, deliver to the buyer, if required by law, fully completed federal lead-based paint disclosure. And that's for homes that are a certain age and older. Many realtors want them no matter what. So you might be, if you're working with realtors, you might have to fill this out. Even if you can read on its face, it doesn't apply. I've learned, why fight the broker? Why fight the realtor? Just have my client fill out the form, even if it's totally exempt because the house is newer than when the date the form kicks in. Unless exempt, fully completed disclosure notices sections of 1102 and 1103. And I have 1103 in the course, and I have the exceptions for 1103 in a separate post in the course. But let me just say this. As someone who sells homes for people who need work frequently, I've sold a bunch of homes, many homes for trustees. I've sold for sellers who are concerned about things like the garage. The garage wasn't permanent. I've sold those houses for people multiple times. I've consulted on many more. Let me just say, okay, so where was I going with that? So even if you're selling to professional buyers, and even if the buyers are saying they're willing to waive, I hope I can get to the language. Somewhere in here, or in one of these forms that we're going to discuss, it says you cannot waive, a buyer can't waive their notices, their rights. So I would so I could sleep at night, I would make the disclosures, and then, they can no longer come back after you because for fraud or failure to disclose, because you've complied with the law. As long as you've complied truthfully, you're fine. Now people, I'm not saying people will never sue. I can't do that as a lawyer. I'm just saying, if you're telling the truth when you're making your disclosures, you're expecting to win because you've complied with your duties under the law, and you're selling as is, and you disclose material facts that you're aware of, then it's done. I mean, that's the theory. It all gets zipped up when when you get the money and they get the deed to the property. Now the property is there. If they discover problems later that you were unaware of, then that's the new owner's situation. And that's the point of these. Get it all on that new owner so you can be free, so you can rest after you sell your home. Okay, so we've got the Real Estate Transfer Disclosure Statement, the TDS, which we will cover in the next video. And we'll cover all these eventually. Natural Hazard Disclosure Statement. Usually escrow can get that from a third party for you. The costs are less than $100. I think they're sometimes $25 or $35. And when I'm working with escrow, I just say, can you order it? And they do. And that complies with your duty. Now there's other, if your house was a meth house or something like that, you're going to want to disclose those things if you're aware of it, right? And then there's other tax things and Melrose and HOA. All these things are important. Now, the California, and we're going to discuss those in the course, and they'll all be there. But right now, we're building that in the course. Right now, we're covering the SPQ or the ESD. So we're going to look at the TDS next, and the Seller Property Questionnaire or the ESD. Now, if you're not using the car, and the SPQ is lower down in one of these sections, it says, oh, here it is. Within the time specified by 14A seller, unless otherwise exempt from obligation to provide a TDS, shall complete and provide buyer with a seller property questionnaire. That's SPQ. So this contract requires the SPQ for most sellers. Now, this is a good thing. If you go through, we're going to read the TDS together. We're going to look at the SPQ. The SPQ goes into areas that are, you can just see that commonly cause problems or are important. And by going through it, it's going to jog your memory. You're going to put out the information. You're going to be saying no, no, yes, yes, no, 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 no. And when the buyer reads through this stuff, assuming they have trust in you, it's going to make them more comfortable. That's why I would have these things before they working with a buyer's agent, if you're doing open houses, or before, before they make an offer. Let them see all this information. You're going to get strong offers. So I would say go to the workshop, fill all this out ahead of time, and you'll even have it ready for your agent. It'll help you with pricing. Really, how can you price your home if you haven't gone through all this and figured out what your issues are concretely? So then you can say, well, given that this house is 25 years old, all these comps, these houses are about the same age. These are probably all just common wear and tear problems. There's nothing unusual about my house, in fact, but it's got great views. Therefore, I'm going to figure out what the values are based on the comps and figure my house is worth more. Or my house is only 10 years old. It seems to have a lot more problems than my neighbors. Maybe I need to either fix these up or realize this is going to be an issue, and I will, if the buyers bring it up, I will agree that, we'll give them $10,000. We'll sell the house for a little bit less or whatever. Let me just say it's better to disclose in a seller's market like we've experiencing since, for the last 9 years. It's better to disclose because the buyers will, the way it really gets hurt is a buyer, you don't tell the buyers anything ahead of time. They make an offer, then their inspector finds it, and then they lose confidence in the transaction and they want a big discount from what they offered, as opposed to sometimes they're like, well, this is a $3,000 situation. Do you want to split it or whatever? You can always say no. But when they see a big problem, they haven't heard about it, then they lose confidence. They're like, the only way I'm going to buy this house is for $70,000 less or things like that. This happens. So disclose ahead of time. So in the next 2 videos, we're going to be discussing the transfer disclosure statement and the SPQ. So this is the introduction. It's contract driven and statutorily driven, and we're going to help you disclose. And like I said, if you do these disclosures ahead of time, it's likely to help you get more money from the buyers, even the professional buyers. So winnerscheck.org, join the workshop. For the next few weeks, we're going to be having live workshops for the people who join just the free basic course. It's not going to be more expensive to join the live workshops. So, and once we get a lot of information from the live workshops into the video course, then the live workshops might be something extra. But for now, we're going to have weekly live workshops for all the members. So go ahead and join. Submit your questions on top of or in the comment section or sometimes in the questionnaire. And I'll be prepared to answer them live during the workshop. And we'll also have a Q&A section where I will try to answer questions if I can. All right. Thank you. John McConnin, winnerscheck.org.